Let me put it in somewhat different terms. You work for the Attorney General, right?
I do, Your Honor.
Okay, and the Attorney General may prosecute.
Correct, Your Honor.
Has authority to do that.
Correct, Your Honor.
Now, is the Attorney General aware of the situation?
The Attorney General is not. My supervisor
I'm
is.
not interested in, there's only one Attorney General.
Okay.
The Attorney General aware of the situation?
I have provided no report to the
You will provide this information to her in the next 48 hours.
I will, Your Honor.
Okay. And she could, or somebody in her office could prosecute these cases if she thought that this was a serious matter that was not being handled by the local authorities. There is an authority in California.
Absolutely, Your Honor. And
has that happened? Has an investigation been done? Have any steps been taken to show that California does not condone prosecutors getting on the stand and lying to the jury in a criminal case? Anything like that happened?
in this case, Your Honor,
Yes, in this case.
I guess my answer is, I suppose, other than the criticism from the Court of Appeal, the answer to that is no.
Well, the Court of Appeal is not work for the Attorney General, right?
Correct.
Okay, so anybody from the Attorney General has any, is there any idea to prosecutors across the state that if you get on the stand and lie about it and get caught, you are going to have to deal with the Attorney General and the possible prosecution for perjury?
Well,
Anything like that?
that has not happened, although, as I said earlier, I do not believe that
Any particular reason why that has not happened?
Well, the reason I have not done it is because I do not believe the proof shows that Mr. Weingrad lied. The Court of Appeal...
Have you done an investigation? Have you sent out... I mean, normally when you have a crime, or potential crime, you send investigators, you talk to people, you take evidence.
I have not done that.
Have you done that?
I have not.
You have the authority to do that, do you not?
My office does.
With the approval of your supervisor.
Yes, and she also has prosecutorial discretion. But so we could, without question, we have the authority to do those things.
Yeah, well, I have to say that your office, now under a prior Attorney General, but your office fought tooth and nail to keep the 1998 sentencing transcript away from the Court of Appeal.
And if I could address that, Your Honor, I agree that that does not look good.
No, it looks terrible.
But here's part of the reason why that was not inappropriate in my view. The Court of Appeal certainly, and Mr. Hennessy should be commended because he's the one who fought to bring this all to light as the appellate lawyer. But the Court of Appeal, when they saw that there was a potential problem, should have said, there are things here that we need to look at outside the record, the very things that you're talking about, an investigation, and consequently this claim should be raised as a habeas corpus claim.
The problem is, why should Bacchus counsel have had to fight tooth and nail for this information, which was part of a court transcript?
But it's clear that Bacchus counsel didn't have to fight for it. He had it from the very beginning.
No.
That's not so
The question I addressed is whether or not the Court of Appeal gets to see the sentencing transcript, and your office bitterly argued that it was not subject to judicial notice and that the Court of Appeal should not look at the 1998 transcript. They nonetheless look at it, and they also look at the 2002 resentencing when it was finally readjusted because of the difference in good time, which is what Silva had been saying happened in 98. And when they look at those two things, they conclude that Silva lied. But I cannot imagine that when the Attorney General's office was trying to keep the 98 transcript away from the Court of Appeal, that it was doing anything other than trying to keep information that was inculpatory of Mr. Silva away from the Court of Appeal.
Your Honor,
Looks sort of bad, and will look terrible in an opinion when we write it up and name names. Will your name be on there? Were you one of the people that tried to keep it out
of
the Court of Appeal?
I was not.
And who was it that that fought so hard to keep it out?
It's my office, so I am in that regard responsible. But it looks like the attorneys who were involved in that were Mr. Delgado Rucci. And
the letter is signed by Laura Stillwell Studebaker, whom I do not know.
Are they still there?
Ms. Studebaker is not. Mr. Delgado Rucci is. He currently works with me.
Well, he might see his name in an opinion.
But
Is this the kind of thing you really want to press here? Don't you think this is something that you ought to take up with the Attorney General and reconsider? Why don't we give you a week to talk to your supervisor and see if you can work out anything with opposing counsel that will avoid have us decide this case.
I certainly will accomplish any task that the court directs me to, and will report on that.
Get a hold of the Attorney General, get a hold of the supervisor, and see whether they really want to stick by a conviction that was obtained by lying prosecutors, and that was maintained in the Court of Appeal after the Attorney General's office fought tooth and nail to keep out a transcript that would have shown the perfidy of the prosecutors, and whether having that in Fed Third, documented in Fed Third, is really going to further the interests of justice in California.
I will do just that.
Do you understand the question? If you do not, there is not only a transcript of this hearing, but we're on video. You can play the video for your boss and the Attorney General.
And if you would like my memorandum to my supervisor, I'll provide a copy of that to the court, so you'll see what my description of the circumstances and my recommendation for what happens.
It's up to you, but you're way over your time.
Can I just ask him one question? This really troubles me about this case. It reminds me of Tommy Thompson. The prosecution pursued a theory of murder for hire, and under the theory that Tom hired Baca, right?
That is correct, Your Honor.
Well, how come was Tom ever prosecuted?
The answer to that question appears to be no. I can find no record of it, and Magistrate Judge Walsh, as you noted in your without citation, he said that there's been no prosecution. There's certainly been no appeal.
Now it's murder, so there's no statute of limitations. Right. Is there any plan to prosecute Tom?
I don't know if he's even reachable at
this point. What do you mean reachable?
He received $500,000, and so he could be somewhere where there's no extradition treaty. But that's speculation.
But Riverside had him at the time. They put him on as a witness in the first trial.
They had him at the first trial. That's correct, Your Honor.
It's completely inexplicable to me that you would, I mean, he would be the principal in this murder for hire thing, unless it was a totally fabricated theory that the jailhouse snitch made up, along with the prosecutor.
I have no explanation for it. I don't know.
Okay. Talk to the Attorney General, okay? Get her attention.
I will do
Talk to the Attorney General and make sure she understands the gravity of the situation, and she understands that we take it very seriously.
I will do it.
Very seriously. It does not speak well for the prosecutors in California, doesn't speak well for the Riverside County DA's office, and speaks very poorly for the Attorney General's office.
I'll make that very clear, although what I would say is I have to use the chain of command, so I won't call the Attorney General and speak to her myself.
You can find somebody who will.
I will.
Give the word to her.
I will, Your Honor.
Okay, thank you. Mr. Hennessy, anything further? Thank you, counsel. We will defer submission of this case for a week. If a week is not enough, you can file a motion for additional time. If we don't hear in a week, we will submit the case and decide it.
And, Your Honor, I guess it's not clear to me what you expect to hear from the Attorney General.
I would expect, if we hear a joint motion from counsel to dismiss the appeal because the state has decided to move in state court to set aside the conviction and retry Mr. Baca, that would be one resolution. But, you've got opposing counsel. Maybe you can work out something that will pretermit the need for an opinion.
Very well, Your Honor.
Because I don't think an opinion is something that is going to be very pretty.
Understand.
Whichever way it goes.
I understand that, Your Honor.
Thank you.
Thank
you. Okay. Submission is deferred in this case for 1 week. We'll hear the next case on the calendar.